A 1,200-page charge sheet filed by the Delhi police against university student turned activist Kanhaiya Kumar and others has given rise to the sedition debate once more. Among other sections of the IPC, these 10 individuals have been also booked under Section 124A that deals with sedition. The British-era law has been used time and again by successive governments, often against people who criticize them and also against political activists. While conviction rates are usually very, very low, the law acts often as a whip to silence dissent. So is there really place for a law whose purpose and design was to muzzle criticism in modern-day India? Speaking to me on this today is former Attorney General Soli Sorabji, and I'm also joined by Supreme Court advocate and BJP spokesperson Nalin Kohli. Welcome to both of you. I'm going to start by asking Mr. Sorabji whether 124A has a place at all in modern-day India, especially seeing the way it has been used in the recent past.
Well, 124A, the Supreme Court has made it very clear in its landmark judgment in Kerala that any criticism of the government, however strong, however pungent, however ill-informed, does not amount to sedition. Sedition section can be invoked if there is an incitement to violence. For example, if you say this government is inefficient, it's useless, not doing anything, we should throw it out of the next election, perfectly all right, as a democratic India. That's not sedition at all. But if you say that it's high time we overthrew this government, not by violent means or by means other than going to the courts, then that may amount to sedition. In other words, incitement to violence is the gist of the offense of sedition. Unfortunately, the law enforcement authorities, over-enthusiastic or ignorant, apply the section to cases where it has no application at all.
The charge is that governments are using sedition as a political tool, and isn't that the real concern, Mr. Sorabji?
No, they haven't. When they use it, when they misuse it rather, Section 124A, the court strikes down the action. The courts are very keen on preserving the fundamental rights of our people, of freedom of speech and expression. So if it is misused, I mean, any statute can be misused, thanks to human cunning and ingenuity. But if it's misused, the court will strike it down. And I don't think the government really will put those people in jail because they criticize them. This government hasn't done anything of the sort. Of course, a person who criticizes the government won't be invited to a dinner party by the Prime Minister, but he won't be put in jail for that, for criticizing.
Okay. Nalin Kohli, let me come to you on what we have seen in the recent past. Of course, the most recent trigger is the cases in the charge sheet in the JNU case, where those who have been charged and others, including from the Congress party, say that this sedition tool is being used to suppress dissent, considering that this charge sheet has come 3 years later. And just a few months before the election, sedition has been used in a case in Assam, where there is a BJP government ruling, where a very senior writer, Sahitya Academy Award winner, has been charged with sedition. In Manipur, a sedition charge was made. When the court kicked that out, NSA was then applied to an Imphal-based journalist. The pattern seems like this government wants to muzzle dissent.
I'm going to keep the discussion apolitical because we've got someone very senior in law, Mr. Sorabji there, and we don't have a political panel here. No. And I'll speak more from my legal hat. Let me first build onto the issue of sedition and take the debate further where Mr. Sorabji, my eminent senior and most respected friend, said a few things. Well-wisher of mine. I think the first point we need to understand that sedition is part of the statute book. I don't find this a healthy argument to say, oh, there's no place of it in modern India. 1860s, when the Indian Penal Code came into existence, 30, murder, rape, all of it are in the same statute book. Just because over 100 years have passed, you can't say that this is outdated. Law is in a context, those provisions are there to protect the citizens. Now, there is no other statute or there is no other section that would be available if somebody actually was waging a war or spreading disaffection, being a key word, inciting violence in terms of the overthrow of the government. That's why Section 124A is even today part of the statute, and it is not constitutionally been struck out by the courts, whether it's Balwant Singh or it is later the Kedar Singh case. So essentially, the courts have intervened, seen that due protection is there. Now come to the question of misuse. False rape cases are filed, false dowry cases are filed, false murder cases are filed. Does that mean you throw them out of the statute book? You don't. That's where the courts come in to protect the rights of the citizen.
Yeah, but you know,
and in every case where the statute or a section has been incorrectly used, let me finish. It's a serious discussion. Wherever it is there, the courts have done so. Now let's break down what is sedition. Sedition, or it was in the case of even in terms of Facebook posts and others, when the court found that Section 66A of the IT Act did not satisfy what are the basic protections for citizens and their rights, it struck it out. So in this case, essentially it's not about criticism of the government. We all as citizens have a right to criticize the government. The question is whether implicit within that is there any attempt to want to spread disaffection or incite violence. Now I'll come to the JNU case as you asked the question to end with it. On the JNU case, if you ask me as an advocate, somebody stands there or a set of people say, Bharat ke tukde tukde karenge, which means essentially we are talking about breaking up the country or the balkanization of India. In that entire IPC, I don't know what other section would you bring. So therefore, it is in the statute book, it will be used. Should Parliament in its wisdom ever define it further, remove it, bring a new law, then that would be dealt with. But today to say that it finds no place because the courts have ruled on it and the courts haven't struck it out either, that would be incorrect to say it finds no place in modern India.
No, but that is the
because
question.
If you have a situation
that is the
where
question.
someone is inciting violence or this,
because
what choice
Nalin
do you
Kohli,
have?
I agree with you that there are a lot of laws from 100 years ago which may still make sense, but is sedition one of them is the basic question of this debate, for the simple reason, look at the means and ways of communication that have opened up to people today. And in those means and ways of communication, the vast majority of people who are able to express their views. It is a law which has been misused so often, and hence it begs the question that is it required, because it talks about an act of speech. And if there is a real effort to harm the state of India, aren't there enough other laws to cover them? Do you need to have a law which can drop people down just because you didn't like their Facebook post or they don't agree with you while you are in government? And I'm sorry, I know you are a noted lawyer, Nalin, but you are also with the BJP, and we're talking about what the current government is doing. So in that context, you will have to bring in your BJP hat as well.
Well, first of all, let me also point out something interesting which people fail to study it, because we mustn't read any law or any section in isolation. The Constitution is the basic document. From the Constitution, everything will flow. Now let's go to Article 19. Article 19 is freedom of speech and expression. Most people don't realize that the First Amendment to the US Constitution was expansion of the fundamental rights in terms of freedom of speech. No restriction, absolutely no restriction. Whereas in India, the First Amendment included bringing in restrictions on what is free speech, where in terms of public order or other things were added as the reasonable restrictions. So when the Constitution has Article 19, where freedom of speech and expression has reasonable restrictions, from that premise, if you are going further down, the basic implicit thing is that you have a right to free speech, you do have a right to criticize the government, but that line is also within a Lakshman Rekha, if I may say, that you can't cross it where it incites violence. Implicit in it is disaffection of the government that may lead to any kind of inciting of violence or calling for the balkanization of the country. That also will flow from the same. So therefore, you can't look at it only in isolation as 124A. The last point is about your question related to, say, technology, means of communication. Law also evolves with it. You didn't have electronic or a WhatsApp or other things, say, 10 years ago. You've had divorce messages going out or triple talaq going on WhatsApp. So you now are able to take electronically through the Evidence Act, include these things as forms of evidence. So law keeps up track with it. But to say that a new means of communication has come in, therefore a section has become obsolete, when it has to do with free speech in a sense, I won't agree with that.
Okay, let Mr. Sorabji come in. So you wanted to give your point of view on the basic...
Oh yes, and the BJP question, I forgot.
No, the BJP hat is on.
I can answer on the BJP part.
No, that wasn't a question, that was an observation.
If the government was guilty,
if
the government was guilty...
Yeah, that wasn't a question, that was more of an observation.
No, I forgot about that. I was not evading it.
No, yeah, you'll have a chance to come to it, but Mr. Sorabji indicated that he wanted to come in, and I'm keen to go to him. On the basic question of the debate, let's come to that then, Mr. Sorabji, of whether the sedition law as it exists today has place in modern India and also in the JNU context.
Well, sedition law has been upheld by the Supreme Court by restricting its applicability to acts or statements, words spoken or written, to acts which instigate violence, which incite violence. And I think there's nothing wrong in that. After all, you can't incite violence. There must be public order. You can't disturb public order, which is the basis of civilized life. The only question is, it has been misused by different governments, mainly because of the ignorance and lack of knowledge of the requirements of sedition law by the law enforcement agencies. And one important thing I would like to say is that sedition law is not per se unconstitutional. Sedition law, as interpreted by the Supreme Court, is within the within the restrictions in Article 19(2). Mind you, the heads of restrictions, sedition was supposed to be one of the heads of restriction in 19(2). But K.M. Munshi opposed it in the Constituent Assembly debates, and it was omitted. So the result is, I repeat, criticism of the government, however vigorous, however pungent, however ill-informed, does not amount to sedition. But if its criticism means not replace the government in the next election, but let's overthrow it, it's tyrannical, it's despotic, by violent means, that is sedition. And to that extent, sedition law is required, and it should be properly applied in that proper perspective. It's interpreted by the Supreme Court.
Specifically in the context of JNU.
Other judgments of the Supreme Court, to make you emphasize.
Yeah, Mr. Sorabji, in case of the JNU case specifically, where prima facie, from what is reported about the charge sheet, there was a group of people raising slogans in a university. Some of the people who have been named in the charge sheet were seen there, though there are some reports now that say that in the charge sheet they weren't speaking themselves, there were people around them. A group of students raising slogans in a university, do you think that fits what the 1962 judgment meant when it was demarking the scope of sedition?
But what are the slogans? If, as Nalin Kori said, the slogans are tuk de kar dega, that certainly, then the sedition law comes in. But the slogans are remove the government, let's throw it out at the next election, or let's combine, make a coalition and let's throw out the government, which is absolutely disastrous for the country. That's not sedition. Just is incitement to violence. And that all depends what are the slogans. I don't know, but they're really anti-national, and what do you mean by anti-national? But I repeat that if it was stated that tuk de kar dega, that's what Nalin Kohli said, then it certainly amounts to sedition, and we require a sedition law in such situations.
Nalin, let me come to you with the question that is being asked, that suppose there is someone who is making this claim, there are university students who are making this claim. Is their mere act of speech something that could harm the country of India and then deserves to be slapped with sedition? There could be other laws, but a law which is vague enough to misuse, is that really required then?
Well, let's ask it from a counter perspective. Why does one go to university to explore ideas, to study, to follow up academic pursuit? Where is the space to say, कि अफजल हम शर्मिंदा हैं तेरे कातिल जिंदा है? Who is the qatil? The Supreme Court for passing the order of the hanging, confirming that death sentence? Or say Bharat hum tumhare tukde tukde kar denge inshallah? What is the need for it? Then to say that universities haven't had situations of violence, what happened during the whole Naxalbari and the Naxalite movement in Bengal? It was all in the universities that it started. So these are arguments of convenience by those who have a stake to say that yes, this can also be an avenue for us. I think if you say that the BJP government has gone ahead and misused sedition, every day someone or the other speaks something ill about the Prime Minister, speaks in words that I can't repeat in TV also. They are very personal comments. Some of them even are very impolite words. Is there a case of sedition against any one of them? Perhaps some people will rue and say that we are a country where people can say many things. But there is a line, and that line cannot be crossed, because there is also a defamation law. That defamation law is also based on the question that there are reasonable restrictions. I have a right to wave my fist in the air, but my right ends to where your nose begins. My right is not to even hit your nose and break your nose. So therefore, that's where reasonable restriction is. That's the Lakshman Rekha. So I think what the point is, if there is a case of misuse, that's where the courts step in, and the courts have stepped in. In all the cases you've raised, I can tell you equally there are a number of cases of dowry law misuse, murder misuse, rape misuse. That doesn't mean that the statute is bad or the section is bad.
Okay.
If it's been incorrectly used, one who uses it incorrectly has to be punished.
Yeah, but the one who uses it incorrectly is rarely punished because they're successive governments and law enforcement agencies, as Mr. Surabji spoke about. So we know that there is misuse, and that is also illustrated by the very low conviction rates. That in that case, Mr. Surabji, is it enough to leave it to the courts? Because the whole process, while it goes on, meanwhile, puts the person accused perhaps wrongly at peril. Their life is hanging in the balance while this whole sedition law plays out, till a court throws it out. And the people usually misusing it are the ones in power. Do you think that that is an all right situation that we should be comfortable with?
Well, that risk is there. Any law can be misused, unfortunately. But the point is that sedition law cannot be applied to criticism of government. The prerequisite is incitement to violence. And incitement to violence is a gist offense, and I don't see anything wrong in that. Whether on the facts of a particular case there was incitement to violence or not will be decided by the court. Of course, the court should decide it quickly, because till that time is decided, the person concerned has to undergo a lot of trouble. But I think the correct position would be really to educate our law enforcement authorities, impress upon them the necessity of the requisites of the section, provide for compensation to the injured party if they have been wrongly charged with sedition law. But I would not say that it should be repealed altogether. In certain situations we need it, we require it. But those situations are of a very limited kind, as said by our Supreme Court, that it must be only in those cases and not cover the criticism of government. We have a right to criticize the government, but we have not a right to say oath of the government. Now peaceful means they have failed, but we must oath of the government. That's an incitement to violence. It's a thin line, but then the courts will decide on which side of the line you fall, a particular case falls.
Well, an 80-year-old activist in Assam, Hiren Gohain, has been charged with sedition. He's a Sahitya Academy winner, Cambridge scholar, and he too will wait for the courts to decide, as will many other people who are charged with sedition. Conviction rates are low, but meanwhile it continues to be a tool in the hands of successive governments. You heard what our panelists have to say. Tell us what you think. Do you think sedition law still has a place in modern day India? We're waiting to hear from you. Thank you for watching.